Welcome to the Meaningful Mediation Podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. Welcome back to the Meaningful Mediation Podcast. This is the show where we talk with lawyers, mediators, and negotiators who spend their careers negotiating. The idea behind this show is pretty simple. We sit down with the people who actually do this work and ask them what they've learned. My guest today is Eric Ostroff. Eric is the managing partner of Meland Budwick here in Miami and is the chair of the firm's Trade Secrets and IP group. He's the only Florida lawyer ranked by Chambers in both commercial litigation and intellectual property. He sits on the steering committee of the Sedona Conference Working Group on Trade Secrets, and he also happens to teach the Trade Secrets class at the University of Miami School of Law. Eric, welcome to the Meaningful Mediation Podcast.
Patrick, thank you for having me.
My pleasure. So before we dig in, I want to give people a feel for what your practice actually looks like. So trade secrets and non-compete litigation isn't necessarily ordinary commercial work, and the parties oftentimes know each other. So the leverage may shift day by day, and somebody's always maybe racing to the courthouse. So how would you describe what makes negotiation in that world different from, say, a normal commercial case?
You know, I heard a federal court judge say once at a seminar when he was speaking that his trade secrets cases are the closest thing he gets to family law, because you've very often got this sense of betrayal, trust and betrayal. I mentored this person. I taught them the business, my secret sauce. They wouldn't be anywhere without me, and now they've left and they're stealing my customers and they're attacking my business. So there's oftentimes very intense emotions, and it can be challenging. It can be challenging from a settlement perspective.
Yeah, I mean, family law cases are really contentious, but when you put it on that kind of level, for intellectual property. And we see this also in business divorces too, right?
Sure.
It gets personal. People get angry. It's their lifeblood, so to speak.
Yep.
So you sit on the steering committee of the Sedona Conference Working Group on trade secrets. And what are people in that room most concerned about? And what should lawyers and mediators in this space be paying attention to right now?
Yeah, it's trade secrets law has historically always been governed by state law, just like non-competes are and still are governed by state law. Starting about 10 years ago, there was a federal cause of action, so there's now more federal litigation for trade secrets. There's non-compete litigation is really a big part of trade secrets. It's one of the primary methods for protecting proprietary information, restrict where your employees can work in the future. That law changes a lot. We saw under the Biden administration, the Federal Trade Commission actually tried to ban non-competes, wholesale. That was struck down by the courts. And now we're seeing a lot of state law changes in the non-compete area. Most states are going to the direction where they're narrowing non-competes. Florida is an outlier. It went in the complete opposite direction, passed a law last year that radically expanded non-compete enforcement. So there's a lot of state law-driven changes, particularly in the restrictive covenant non-compete space.
And I guess business got better for you maybe here in Florida with the change, no?
Maybe. It's interesting. It's the law was just passed last year, and I don't want to get too into the weeds on this, but it's such a restrictive law it's interesting to see. It'll be interesting to see if you have to meet certain requirements before you can fall under the new law. The old law is still in effect if you don't qualify for the new one. I haven't seen a lot going on with the new law yet, but it's, I think, designed to attract more companies to Florida who want to take advantage of those protections. And we'll see if that's the case. Certainly you got California on the other end that effectively bans non-competes except for very, very narrow circumstances. Florida's taken the total opposite approach, and we'll see.
And so, just so our listeners understand, Florida used to limit the non-competes in terms of, if I remember correctly, it was enforceable if it's limited by time and location, right? If those are reasonable. And now it's a little different. What is the difference? It's a little more open, right?
The old Florida statute, which is still effective, Section 542.335, has always been the most pro-employer statute in the country. And you do have, the court has to figure out what's reasonable, time, geography, and the court, if what you have in the contract is too broad, will narrow it. A lot of other states, if it's too broad, it gets voided. There are certain presumptions in the statute. So if for a former employee, 6 months or less is reasonable, 2 years or more is presumptively reasonable. 2 years or more is presumptively unreasonable. Protecting, if the non-compete is protecting trade secrets, anything 5 years or less is presumptively reasonable. With the new statute, but with the old statute, you still have to show a legitimate business interest, so customer goodwill or trade secrets or confidential information. With the new statute, if certain requirements are met, which include you have to give notice of the right to an attorney, you have to give 7 days to consider it. The employee has to acknowledge certain things, like they have access to confidential information. If you have a and there's income thresholds too. Yeah, it has to be basically twice the mean wage in the county. So if you're above that level and you sign a contract under the new statute, then any non-compete up to 4 years long, regardless of geographic restriction, so it could be worldwide, the court must enter an injunction. So there's not even a defense. So you bring that into the court has to basically rubber stamp it, 4-year injunction. And at that point, the burden shifts to the defendant to prove, not by preponderance of the evidence, but by clear and convincing evidence, basically that they're not violating the statute. So, it's an extreme outlier of a statute. My guess is that very few other states will enforce it if someone tries to sue in their state. New York has already said, the Court of Appeals, which is the highest court in New York, has already said that the old Florida statute, 542.335, is repugnant to the public policy of New York, and it won't enforce the old statute. So I think we're going to see, a lot. There could be races to the court by employees to sue in another state if they have the ability to get out of the statute. It's an interesting approach, very different from where other states are handling non-competes.
Yeah, it's a tough one here. Well, it depends on which side of the fence you're on, right? If you're the employer, you like it. If you're the employee, could be tough.
Yes.
Now, your Law 360 piece this spring talks about the updating protocols to protect trade secrets from AI, which is an interesting point. So tell us more about that.
Yeah, I mean, AI obviously affects everything. It's just, it's everywhere all the time. And it affects companies trying to protect their proprietary information as well. And what I wrote about in that article was the concept of AI agents and employees using AI agents just to do their job. But if those agents are given access to companies' systems, if the systems aren't configured in a way to block that type of access, and the employee has control of this agent and then leaves and still has that access post-employment, then whatever that agent learned has left the building. And it's not, trade secrets law was built to address human beings and human activity. So on X date, John Smith accessed the server and downloaded the following data. AI doesn't interact in the same way, and these agents have constant repeated access. And it's something that companies need to think about. How does AI change? How does AI change the way that they're protecting information? I just wrote a blog post last week about NDAs and what happens. And every NDA says you can't share the confidential information with third parties. And then most of them say when you're done, you got to destroy all the information and you got to certify destruction. So what happens if you have an employee who gets information and takes it and throws it into ChatGPT in a consumer account, not an enterprise account, where they're going to ChatGPT is now training on this data. So was that a breach of the NDA? And then when the term ends and the information's been fed into ChatGPT, how can you certify that it's been destroyed? And I think that's a problem that really affects virtually every NDA that's been signed. And there's probably millions of them. They just weren't drafted with the anticipation of this technology where, it's not like uploading a document to Dropbox where you can just pull it off.
Yeah.
Once it's in ChatGPT, that's it. Who the heck knows where it went? So it's an interesting, a lot of interesting issues around that.
Yeah, there's so many challenges with the emergence of this new technology that it feels like every day we're learning something new and a new impact and how to, reply and respond to it. Well, how about this one? And I've been thinking about this one, and I'm sure this has come up. So what do parties do when they learn that someone's confidential information or maybe their work product, it could be, photographs or something proprietary that they created, ends up being consumed and used by an AI model? Have you dealt with those type of issues?
I get concerned. We talk to clients about it because clients are taking your memo and throwing it into ChatGPT. I mean, we warn clients against doing that. There's been some cases about clients without consulting lawyers using an LLM, and there was a decision in New York that said that doesn't. There's no privileges to that. It's problematic, and it's just become ubiquitous. Everybody uses it all the time. So it creates a lot of issues.
Yeah, I was even thinking about, like, say, the music or art world, where somebody takes an original piece by an artist, throws it in there and modifies it just a little bit, right? Lets AI do it. So whose product is it?
There was a whole. So I'm not a patent lawyer, but there was this individual who used an AI to create an invention, and he tried to get a patent for it. And when you get a patent, you got to say who is the inventor. And he said the inventor was the AI. And it went all the way up, I think, to the Federal Circuit, and the Federal Circuit eventually said that an AI can't be an inventor under the patent statute. I think it's an easy fix. You would just say the human being who interacted with the AI. But there's so many different ways that the law is going to have to adapt, because this is just not something that the law wasn't built with this technology existing.
Yeah. In that instance, one could say that the AI was the tool, but the person using the tool is the inventor.
Yes.
I guess you could make an argument like that.
Yep.
Well, let's pivot to some of your most well-known representations. I saw there something about Glenn Beck and Mercury Radio Arts, for example. This involves high-profile parties or very public industries. How does that kind of attention shape how a party negotiates?
Yeah, I mean, I'm not going to talk specifically about that case, but in general,
Mhm.
when there's publicity involved, then that becomes a factor. So how is this going to, how is this going to be? If there's media coverage over a matter, the fact that it's settled could be newsworthy, and you have to account for how is the messaging going to be allowed to be done, post settlement. in a typical case, you have a confidentiality provision in the settlement agreement, and it says something like the parties have amicably settled this matter. That doesn't always work in a PR heavy environment, a place where there's going to be media attention. So I know that in cases that I've dealt with, we've involved the PR people in how are we going to how are we going to be able to message this afterwards? What do we need to be able to do? And then you got to make sure that you're allowed to do that in the settlement agreement. There's standard settlement agreement with confidentiality provisions. You could be hamstrung. So it's a matter of preserving the flexibility to handle it from a PR perspective the way you want.
Yeah. Being proactive about it, thinking about those possibilities beforehand before you sign on the dotted line, right?
Yep, exactly.
So, Eric, everyone I have on this show has at least one case or an experience that changed how they approach or work on the next one. What's your experience that did that for you, and what did it teach you? Some sort of defining moment, let's say.
An experience that changed the way that I looked at the next one. That's a
Or
good.
change your career path, the way you do things.
So when I was younger, so we're talking probably 15 or so years ago, and I tried my first non pro bono jury trial, and that process, and in commercial litigation, trade secrets litigation, trials are not extremely frequent. Although I try a lot of cases, but jury trials are even more rare because oftentimes you've got waivers in the contracts. If there's a contract, more often than not, there's going to be a waiver. But just the process of having to think through telling the story in a way that lay people can understand and will in a way that'll resonate with them. I think that was a really formative experience. And trade secrets cases are very much particularly when you're on the plaintiff side, you're trying to tell a right versus wrong. This person stole from us. This person, this was someone that we trusted. This is somebody who benefited from their relationship with us. Oftentimes made a lot of money, and then they saw something that was good and they took it for themselves. And those kind of themes, I think, resonate with jurors.
And did you learn this like by trial and error your first time? Did you feel like there was something missing and that maybe the storytelling was a better approach, or it just came naturally to you?
Yeah, it required a lot of real deliberative thought. By the way, this is something I think AI can help with now. So I'll use AI to help develop trial themes and give me feedback on opening statement, closing argument, trial outlines. But back then, obviously it didn't exist. It required me really sitting down and thinking long and hard, just talking with other people, talking with my non-lawyer friends to get their thoughts on something like this. What would resonate with them? So it was the process that kind of formed my way of thinking about it.
Very good. And you have like a round table at the office where you go through
Yeah,
different variations of what you would be doing and see which one resonates the best?
yeah, we definitely have other people sit in on an opening statement, dry run or kind of a mock trial with themes, things like that. Yeah, you want to get as many brains to give you opinions as possible.
Do you do something similar for like a high stakes negotiation or even a mediation where maybe you have different approaches and you roundtable that too? Should we do A or B, or how does this sound?
We definitely discuss through settlement strategies. How are we going to, what's our opening offer going to be? How do we, how do we anticipate this proceeding? So yeah, that's absolutely something that we have a very collaborative culture here at our firm, and we spend a lot of time talking through, how are we going to handle this high stakes mediation?
Well, I've been there, and do you still have all the glass walls?
Yeah, and you can see one behind.
That leads to collaboration, right? You can
Right.
see each other.
That's right.
So, um, this is a good place to start and pivot to the practical side. And I call this the mediation toolbox. So, what would you say are your top tools and strategies that you use when you attend mediation?
So I have a contrarian view, I think, to many people, which is that I like virtual mediations. Um, I think that a lot of lawyers don't. Um, I find that people have more stamina when they're not trapped in a conference room all day, and they're able to, in the downtime, turn off the camera and do other work. Um, I find that many times somebody's coming from out of town and they've got a flight at 7 p.m. and that ends up causing some sort of difficulty in getting things done. So I personally um, I like virtual mediations. Um, I also like to spend some time with my clients. A lot of business people they find the mediation process to be a very alien way of negotiating. And they're used to just kind of getting to the point with somebody. And, I like to get them in the mindset that you just give up your entire day. You expect you're going to be here for, late in the day, evenings, maybe past dinner, and expect that it's going to go slow and you got to work the process. You can't just jump to the middle because, the way that this works, that's very likely to get a result in a less favorable settlement for you, or you're going to be giving out too much information when the other side hasn't earned it yet. So I think that spending time with business people to get them prepared for the kind of alien environment that mediation is important as well.
Very good. I like that. And, to go back to what you said about virtual mediation, I prefer to call it online because it's real. It's not
Fair
virtual,
point.
right? It's a
Fair
real
point.
mediation. But back to online mediation, um, there's something to be said for a person's comfort level. And I'm not mean, are they sitting in the right chair and I'm talking about being in their own environment, in their own home, their own office, having access to their own things, not having to jump on a plane or hop in a car, fight traffic, go to a foreign place, hop in a lawyer's office in a conference room and be surrounded by a bunch of people that maybe they don't want to be in front of, right? Oftentimes that anxiety level doesn't sit well to begin a mediation. And I'm finding that, through online mediations, people already have a more calmer demeanor because they feel they're in control. They're in front of their camera. They're in their own place. And there's a lot to be said for that. And I think people underestimate that power.
Agree. Totally agree.
Um, yeah. And I also like what you said about prepping your clients because mediation is a different process. And oftentimes, depending on your negotiator, some people, like you said, want to get right to the point. Some people think they've always are used to getting what they want. Yes, sir. May I have some more? That kind of, depending on the personality you have on the other side, if you're dealing with a very high corporate rep. But it doesn't work that way when you got two other parties. And so prepping them on the process and what they can expect and how it proceeds is really important because the last thing you want is a person to come in and be confused, right? And or getting upset and expecting one thing and receiving something else, right?
Sure.
Yeah, excellent. Um, the next section I have, which is one of my favorites, is the top 3 tips for better negotiation outcomes. And this is not limited just to mediation, it's negotiation in general. So, what would be your top 3 tips for obtaining better negotiation outcomes? So, if you could put 3 things in front of every lawyer, what would those 3 things be that actually move outcomes?
So one thing that I think in the mediation context is important is at this point, I almost never will do opening statements anymore because I feel like that causes emotional issues and can be counterproductive. I think it's better to get into a collaborative isn't the right word, but into a mode where you're thinking more about resolution as opposed to fighting. And I find that the opening statements more oftentimes do more harm than good. It's not always the case. There are some times where this is your only opportunity to speak to this decision maker on the other side, and it's important to do it. But to me, that's become more of the exception than the rule. I think it's important to understand when is the right time to initiate, and understanding, how to leverage, how to leverage milestones in the case that are going to change the risk profile for both sides, and the risk drives a lot of resolutions here. And when someone's facing, when someone's not facing any events in the near future that are going to change that risk outcome, they're going to be very committed to their own perspective on the case, and it's going to be harder to move. So I think it's important to think through where you are, when do you want to initiate mediation or negotiations, and it's a successful resolution really starts with getting on the same page with your client, understanding what are they looking for, and getting them. Sometimes, many times, clients are looking for something that's unrealistic. And starting a negotiation at a time when the client is expecting something unrealistic is not necessarily going to work. It's unlikely to work. So there can be times where you have to work with your client over a period of time to get them into a point where what they're willing to accept is within the realm of possible settlement. So you have to have your client in the right place as well before you start a process, if you're really looking to get it to a resolution.
I like those three. The first one, I think, is pretty critical, but in terms of how you approach whether to do a opening statement or not. So has this been a recent change? So since Zoom, or like, when did you decide that maybe you're doing less and less opening statements?
I think it predates Zoom. I think it's, we're probably talking, I don't know, if I'm probably try the last 10 or so years, maybe a little bit less. Whereas, first half of my career was all about make the opening statement. And now I've toned it down. I just don't find it to be particularly helpful most of the time.
Are you able to, as you would say, tone it down? In other words, can you provide an opening statement that doesn't sound like a litigator?
Yeah. Look, you have that as a trial lawyer, you have to be able to deliver the message you're trying to deliver. It can't just be one gear, pedal to the metal, and that's it. So there's an art in delivering. If you're going to make an opening statement, the purpose can't be to inflame. It can't, it's got to be to persuade. Unless, there could be a rare situation where you got a court-ordered mediation, you're not going to settle the case, and you want to deliver a certain message. But if you're really trying to settle, you need to think through what's going to actually be persuasive to the other side.
Have you ever approached an opening statement where, instead of doing the general recitation of the facts, this is what happened, this is why we're here, this is what's going to happen going forward, that general kind of thing, approached it maybe more collaboratively, where you said, listen, we're here with a common problem. Obviously, we have a dispute, and we can either go one way or the other. We can resolve it today, or, there's always, if we want certainty, we can have that trial. But what can we do today to solve this common problem together? And here are some risk factors that we both face. Here's the obvious cost of doing one way versus the other. Like, you ever have that kind of a conversation, or is that too
I
out
wouldn't
there?
say it's not usually going to be a conversation. I think the lawyers are leery about having their clients engage in a conversation with opposing counsel. It's happened in rare instances, but that type of message is not uncommon in an opening statement, where it's more about, look, I can walk you through my closing argument right now, but that's not what you want to hear. We believe there's a path to resolve this case, and we think that path is going to be advantageous to both parties, and here are the reasons why. And we're here to try and get it done. If not, then you'll hear my closing argument at trial. But our goal is to get this resolved today, and we think it can get resolved. And it's more of it's a softer touch, and I think that's a more effective approach than the closing argument approach.
Yeah, for sure, because they're different forms, they're different purposes, and probably nobody likes a lecture, right? And this
Yeah.
is the doom and gloom, and this is what's going to happen, and the threats. You've
But by the
already
way,
been through that.
you do run into issues where your client wants you to be the aggressive, the aggressive pit bull litigator. So yeah, there's a lot of complexities around opening statements and mediation, and I just think that nine times out of 10, everybody's better off if you just skip it and just get into let the mediator give his or her opening presentation, and just split up and start the work.
And that's assuming that everybody's already exhausted their discussions back and forth, right? There's nothing new to talk about. You already are entrenched, and now it's just a matter of assessing risk and costs and getting the demands and the offers and seeing if you can find a place where there's an overlap.
Yeah, and also hearing from a neutral, third party.
Mhm.
I like feedback. I
Yeah.
like the new mediator to be giving me and the client feedback. First of all, it's a tool for me as a litigator to hear. Here's this person that I obviously respect because I'm using them as a mediator. They're smart. They're qualified. They're giving me. They're pointing out weaknesses in my case. That's good to know. But it's very valuable for the client to hear that. So that I think that's very important as well.
And that also comes into play with your second point, or I think it was your third point, about managing expectations. So if you advise the client that that's something that's going to happen, they will, one, know that you're not in pit bull litigator mode, as you say, right? There's a reason why you're doing what you're doing. And then two, when you hear the critique, if you do hear one or questions from the mediator, that, this is a third person, that we're not paying him to say things to you. This is his view, his or her view, right? And that's powerful and impactful for the client, I assume.
Yeah, absolutely.
Okay, very good. All right. So I got one bonus question for you. What is your best resource or book that you have read for negotiation or, influencing people, trying to get people to do things, so to speak?
Give me 1 second. I have a book over here. Yeah, here it is. Never Split the Difference. It's a very
Oh,
good.
wow.
Never Split the Difference: Negotiating as if your life depended on it, by Chris Voss. It's a good book. He's a former
Very good.
FBI hostage negotiator, CIA or something like that.
Excellent book. And you're not the first person to say that. So very good. Seems to be a very popular resource. I did enjoy that method, right? The mirroring, the labeling, and the calibrated questions.
And then
That whole method.
the second bonus answer I would give is Thinking Fast and Slow by Daniel Kahneman, the Nobel Prize winning economist, about understanding biases and how human thoughts work. I think that's a valuable book as well.
Looks like you and I have some common reading lists. That's also on my list as a very excellent book. Very good. I love that. So, Eric, I want to thank you so much for being generous with your time. You've shared some great nuggets and advice that I'm sure our audience will benefit from. So before we wrap up, where should people go if they want to follow or look for you, get in touch with you?
Yeah, I mean, you can look at my firm's website, melandbudwick.com. My blog is protectingtradesecrets.com. Anyone's got any trade secrets or business litigation issues, I'm here to help.
Very good. Excellent. Well, if you enjoyed this episode, please hit follow on Spotify, Apple Podcast, or wherever you listen. And if you're watching on YouTube, go ahead and subscribe and leave a comment. This has been the Meaningful Mediation Podcast. Until next time, let's have some less dispute and more resolution. We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.